Limitation of liability in maritime law, an anachronism. Unlike most individuals in business, ship owners and some others connected with shipping can rely on a very favorable concession granted to them by a number of states. This privilege is limitation of liability. The notion of limitation of liability in maritime law is of uncertain origin, although it may possibly be linked to the Roman law notion of noxe dedicium, in terms of which an owner could discharge liability for damage to another individual by giving up the offending instrument. There are strong similarities between the Roman institution of noxe dedicia and the implementation of limitation of liability in current United States federal maritime law, which provide for limitation of liability up to the salvage value of the ship and freight. Although it may be impossible to definitely link the said system of limitation of liability with any Roman legal principle, one may draw certain parallels between the two concepts. Both involve the abandonment or giving up of an item which has been the cause of loss for another person. A closely related but distinctly relevant institution is that of abandonment of a vessel in marine insurance. It has been stated that the doctrine of limitation was articulated as early as 1625 by Grotius, and that limitation of liability in civil law jurisdiction can be traced as far back as the 11th century. The main law relating to limitation of liability in English maritime law is the Convention on Limitation of Liability for Maritime Claim 1976, which is incorporated as Part 1 of Schedule 4 of the Merchant Shipping Act 1979. This provides for the limitation of liability of the owner, charterer, manager, or operator of a seagoing ship in a number of cases, the most noteworthy of which is the case of claim in respect of loss of life or personal injury or loss of or damage to property, including damage to harbor work, basin and waterways, and aids to navigation, occurring on board or in direct connection with the operation of the ship or with salvage operation and consequential loss resulting therefrom. A ship owner may also, in the right circumstances, limit liability under other convention. The convention relating to the carriage of goods by sea, which is incorporated in Part 1 of Schedule 3 of the Merchant Shipping Act 1979, the Hague-Visby Rules incorporated in the Carriage of Goods by Sea Act 1971, and the International Convention on Civil Liability for Oil Pollution Damage 1969 or CLC, which is implemented into English law by the Merchant Shipping Oil Pollution Act 1971. United States federal law provides for the limitation of liability of ship owner in Title 46, Chapter 8 of the United States Code. Will here be made in particular to the Federal Oil Pollution Act of 1990. This draconian statement provides for limitation of liability of the owner or operator of a vessel from which oil is discharged or spilled. Although one may get an initial impression that limitation of liability is readily available in terms of that stated, the truth is that an analysis of both federal and state oil pollution law will reveal that the privilege of limitation of liability is being substantially eroded. Limitation of liability. Should the system be retained? It is the argument in this article that limitation of liability is an unjustly discriminatory attempt to subsidize the shipping industry at the expense of other interests. The argument purporting to justify limitation of liability will be dealt with seriatim. Limitation of liability has been justified on protectionist and historical ground. It has been said that the aim was to strengthen the international competitiveness of national merchant fleets, since shipping was a risky enterprise and a ship owner lacked effective means of communication with his vessel. Potential entrepreneurs might easily be dissuaded from entering shipping. Consequently, efforts were made by means of global limitation of liability to attract people to invest in the branch and so build up a competitive mercantile marine. While such an incentive may have been necessary in the early days of shipping, it is no longer so today. Investment in shipping may be considered as widespread enough not to require any discriminatory stimulant. A limitation stated can also produce grotesque results, as in the case of Torrey Canyon, where the limitation sailing was $50 as salvage value. The value of one lifeboat is moreover the widespread use of insurance and particularly third-party insurance considerably reduce any possible risk. Another argument for the retention of limitation of liability is that it would be very difficult to obtain any insurance coverage in respect of claims which are not protected by limitation of liability. Indeed, it has been said that the insurance industry relies on the principle of limitation of liability. This argument is particularly used with reference to cases where CLC 1969 applies, where state has imposed compulsory insurance. Moreover, this line of reasoning possibly relies on the practice in pollution legislation regime, and insurer would be protected in terms of CLC 1969 by limitation of liability even where there is actual fault or privity of the owner without prejudice to the right of the victim against the owner himself. Prima facie, this seemed to be a very reasonable argument. However, one can also validly argue that in the case of unlimited liability allocated against a ship owner, there is nothing to prevent the underwriter from protecting himself by inserting in the insurance policy a ceiling beyond which claim cannot proceed. The argument that insurance can be divorced from limitation of liability has been addressed by Professor Wettstein 1990, who states that the role played by insurance costs in competition seems to have been exaggerated in international discussion. The introduction of unlimited liability would mean only a marginal, if even that, increase in cost. Cannot accept insurance costs as a key argument for limitation of maritime liability. Such arguments are not normally acceptable in other fields, and furthermore there exist other means to give favorable treatment to national merchant fleet and to improve their international competitiveness. This should not be at the expense of the injured parties. It would appear that no insurer would be willing to give unlimited coverage for oil pollution liabilities. Indeed, Protection and Indemnity or P&I clubs specifically insert a ceiling in relation to oil pollution liabilities toward third parties. In this respect, pollution liability insurance can well be said to be an exception. However, even if limitation of liability for oil pollution were to be lifted, that would not mean that compulsory insurance would be effective. A solution which, to a certain extent, may be acceptable would involve the imposition of strict and unlimited liability accompanied by compulsory insurance up to a specific amount. Unlimited liability for oil pollution damage is an unknown. Florida imposes limited liability in respect of cleanup and abatement. There is no limitation in respect for other damages. A number of U.S. states impose unlimited liability on tankers owners for both cleanup costs and for damage to natural resources and to third parties. One may here refer to the legislation of California, where there is an imposition of unlimited liability on a ship owner for an oil spill. There is also a requirement for a certificate of financial responsibility up to a specific amount, which at the moment is fixed at $500 million. Thank you.